Hi everyone, welcome this afternoon. My name is Madelena Viksne. I am a employment lawyer at Sanford Tamarkin. We do employment and disability law, including things like long-term disability, wrongful terminations, harassment cases, all of that kind of stuff. So we're a good resource to have in your pocket in case you ever need a lawyer. And I'm actually going to sort of start out talking about some of the things that are going on right now in the tech world. There's a company called Tech Savvy, which is an independent internet service provider, who is apparently selling the company. So one of the big questions that people often ask is, what happens if my employer sells? So if your employer is selling its company, there's a couple of different things that can happen. There's different types of sales that can happen. So a purchaser could buy the assets or the business. The assets would mean buying some aspects of it and not all aspects. The business would mean buying sort of the business and it continues on as it was. The most common type of purchase, unless the company's sort of going under fully, is a purchase. Excuse me, sorry about that. Is a purchase of the business, which means that generally speaking, in those circumstances, there's the possibility that you will be offered new employment by the new owner. So if you lose your job as a result of the company that you currently work for selling their business, they will have to provide you with full severance pay, up to the extent that your contract might limit it. In Canada, it's the person or the group who actually sold the business who's responsible for providing the compensation for those staff who are affected, who are terminated, who are laid off as a result of the transfer of ownership. If you receive an employment offer from the new company or new owner, you'd have to have a pretty good reason why you won't accept it in order to get severance. It's possible that if the reason is good, such as a complete change in your wages or hours or pay, that you could still get your full severance entitlement. What that full severance entitlement means will obviously depend on a number of factors, including whether or not you have an enforceable termination clause in your original contract with the original employer, whether or not you've signed a new contract with the new employer, and whether or not you are restricted to only your Employment Standards Act minimums by way of a termination clause in that original contract or your most recent contract with the previous employer, or if you have a termination clause and we can break it, which we do basically 10%, 90% of the job. If there's a way that we can break it, then you could be entitled to common law reasonable notice. Common law reasonable notice is the one that you hear about, which is about like a month per year, generally speaking, 3 weeks to 4 weeks per year, depending on your age, your length of service, your sort of circumstances in the job market that you're entering, and your position. If you don't have a good reason for turning down the offer, it's still possible that you could get some severance from your previous employer, and if you just don't want to take the new job with the new employer, but you will likely be limited to your minimums under the Employment Standards Act. You don't have to accept major changes that the new employer might make to you or new owner might make to your job, or that they might try to enforce. You also don't have to accept the terms of any new agreement that are provided to you because you're a continuing employee. So unless you're terminated by the first employer and then brought in under a completely new, brand new contract in the second situation by the second employer, owner, I'm sorry, I keep saying employer, owner, you don't actually have an obligation to sign a new contract. You likely will be required or asked to. And if you refuse to sign, then it kind of is up to the new owner as to whether they're going to allow you to work under the same terms and conditions you had before, or whether they are going to let you go. Large changes such as a demotion or longer shifts or reducing your pay, those things will all be illegal. But there could be a significant number of changes implemented into a new employment contract that you might sign. For instance, it could say that they will respect your seniority from the previous employer, but only for certain elements of your entitlements. So, for example, for vacation pay entitlements, but not for other things. It's a very important thing to look out for when you have a sale of business and a new contract coming in or new employment starting under the new owner. I personally think it's would be a poor idea to sign anything without having an employment lawyer take a look at that contract. Oftentimes there will be things in there that restrict your rights on termination, or things that you just may not catch yourself, that could have a pretty significant impact on your employment moving forward. So if you're being offered a new contract, and you're not just going to continue on under the same terms you worked under before, in sales of a business or at any other point, you should always get it looked at, because we can explain to you what exactly it is that you're giving up, because there's no employer is trying to get you to sign a new contract without it benefiting them in some way. Generally speaking, that will mean that it does not benefit you, whatever the change is. There certainly are circumstances where it could just sort of solidify, especially in the sale of a business, solidify what the expectations are and so on of the new owner, and doesn't, act to your detriment. But most of the time it's because they want to have an updated termination clause in there, or some other kind of updated policy or provision that is most likely going to restrict your rights in some capacity or your entitlements in some capacity, and is not necessarily going to work in your favor. Or if it does benefit you, it might benefit them to a greater extent. And at minimum, it's important to, sorry, my dog, Cora. At minimum, it's important for you to understand what it is you're signing before you decide whether those changes are something that you're willing to accept. So as always, contact our office, speak to one of our intake people. They're very good at analyzing your initial sort of issues when you speak with them, and then they can set you up with somebody to speak with who is a lawyer and can review any changes to your entitlements, any changes to the contract. It's always a good idea also to keep a copy of anything you are ever asked to sign or presented with, please. Keep your original contract if you have one. If you don't have one, you can ask for a copy. Better to ask for a copy when you are not in a potentially litigious situation. And before then, just say you want it for your records, because it's really an important thing for us to have a copy of the original contracts, anything that you've signed that could include terms of your employment, and anything new. And a lot of people sort of along the ways tend to lose them. These are important documents and we need them. So please do keep copies of things. So I have a question from YouTube from Albert. Hi, Albert. My employer fired me for getting into an accident with their vehicle. I told them I was not qualified to drive it, but they forced me to do so, and they fired me for cause. Do I have any options? That's a little difficult to speak to. I'm assuming this isn't just a regular car. Probably needed some special kind of license, maybe, in order to be able to drive that particular vehicle that you did not have. You certainly were entitled to refuse the work. Under the Occupational Health and Safety Act, you are always entitled to refuse unsafe work. So if you did not feel it was safe and you were not qualified, they could not force you. You should have, likely in the future, what you should do is refuse to do the work. And if they cause a problem with that, then it's reprisal, which means punishing you for enforcing your rights under the Occupational Health and Safety Act. which they cannot do. Now, if you got in an accident in their vehicle, I assume that there was insurance related to that. So I'm not really sure what it would have to do with you. Is there anything in writing about the qualification conversation? Is there anything in writing, or do you have any understanding of what those qualifications might be? In any event, it probably isn't determination for cause if it was sort of pushed on you, or at least there might be something there to work with. So I would suggest that you call our office and speak to one of our lawyers who can get sort of more information from you about what your role was, what this sort of driving situation involved, what you meant when you say you weren't qualified, what sort of the scope of the accident is, and review the documents that are relevant in order to give you sort of your options in a personal fashion. Belinda from YouTube, what happens if your business closes due to your employer retiring? My aunt works at a doctor's office and her employer said they're closing in 2 months. She's been there 20 years. If the business is closing because the employer is retiring and there's no sale of business, then the employer who's closing down the business is responsible for whatever severance entitlements your aunt would be, owed. I can't speak to her entitlements specifically. It could be as much as about 20 months, it looks like, if she's been there 20 years. If she's been given 2 months of notice that the closing is happening, then that would be 2 months of working notice, but she would still be entitled to further notice or severance or anything after that, even if she's entitled to only the minimums under the Employment Standards Act. So under the Employment Standards Act, you're entitled to up to 8 weeks of notice or working notice or pay in lieu of notice, sorry, which can be working notice or paid out. So it looks like they would have filled that eight weeks with the 2 months of working notice there. But on top of that, depending on what the payroll is, she could be entitled to statutory severance, which is 1 week per year up to 26 weeks of severance. Payroll would have to be $2.5 million for the company, and because it's a doctor's office, it's a little hard to say how he pays himself out. It might go through a corporation, or a limited liability partnership or something. I don't know exactly how doctors do it. So it could not hit that threshold. If she's been there for 20 years, unless she's signed a contract more recently, it certainly is possible that her entitlements are not restricted by an enforceable termination clause. So I would say she should get together whatever documentation she has about her employment, including any contracts, any terms, any policies, etc., and give our office a call. I'm not sure if she would have been hired as a contractor or as an employee. So all of that will come out of the documents probably in a conversation that she would have with one of our lawyers at our office. But I would certainly suggest that she call us because the employer would be responsible for severance, whatever that looks like. And her severance entitlements could be quite large depending on what the contract terms say. An email question from Regine. My employer has given me an offer for severance with a short deadline. I don't think I'll be able to speak to a lawyer before I have to sign. What should I do? Email your employer and tell them that you require an extension to seek legal advice about the package that they've offered. They cannot have you sign a release that says, we have given her, I've had sufficient time. I confirm. Almost all releases will say something like, I confirm that I have had sufficient time to seek independent legal advice and have done so or opted not to. And I understand what I'm signing and it's voluntary and so on. Your release, if you weren't given the sufficient time, is arguably not enforceable. Even if you were to sign it, do not sign it. If you are unsure about whether or not you should be signing it, don't. Almost always those offers will come back around on the table in the event that they are withdrawn. But unreasonable deadlines usually are not put in place unless they don't really want you to have time to consider. or they just want to get it off their books. It's not always nefarious. It could just mean that they just want to get it done with and deal with this round of layoffs or terminations. And so they're hoping people get answers quickly, sort of to get it off of the desk of HR or accounting or whoever's dealing with it. That said, you have a right to seek legal advice, and all you should be having to do is tell them, I haven't had a chance to get in touch with a lawyer. This deadline is too short. I need an additional 10 days. I need an additional week, whatever. And I would say that when I tell people to do this, about 90% of the time, the employer will agree. If the employer gives you big issues about it, to me, that red flags that I don't really think you should sign it regardless. Because what is the rush? If they want you to sign off on something, they should want you to understand what you're signing off on. One thing that I can just say sort of across the board is that you do not have to sign anything if all you are being offered is your Employment Standards Act minimums. They actually cannot require a release from you for the receipt of your ESA minimum. So that's the 1 week per year up to 8 weeks of notice. And if you've been there for more than 5 years and your payroll is over 2.5 million, the additional 1 week per year up to 26 weeks. Your ESA minimums you get no matter what. You cannot be required to sign a release for it. That is illegal. If you're being offered something on top of that, then that's what you're being offered in exchange for you signing that release. But I would just tell them that the deadline is too short and you need an extension. Ashley from YouTube said, my partner's employer has just told them that they will be moving to a new location. It's a significant distance away from where they are located now. Can they force this change on all staff? So it depends. It depends on how far away it is. It depends on what the reason for the change is. It depends on terms in the contract of employment. If it's a significant difference in distance, certainly I would argue that would be a significant change to the terms of the employment, especially if there's never been a move before. There's never been an agreement to switch to a new location of any kind before. There's not been very much flexibility in terms of what the position and so on are. There is case law that says, I think wrongly, but there is case law that does support, a commute of up to an hour or so as being an acceptable change in distance in location. I think that's pretty ridiculous. But there is something out there about it. I don't think that's really appropriate. Makes a big difference to someone if they used to commute 10 minutes. Now they're commuting more than an hour. But I guess it depends very much so on sort of the factors that are at play in that specific situation. They can't really force the change on their staff, but their staff can choose to accept or not accept it, I suppose. If you don't want to accept it, then, there's the possibility that you could be talking about something like a constructive termination, maybe. But again, it depends on what the contract says, whether there's been changes like this before that have been accepted, what the distance actually is, what the difference in the distance is. If you used to use TTC to get to work and now, if you're in Toronto, and now you're unable to do that because it's not accessible to you via that, then that makes a big difference as well. So I would say that, potentially it's a good idea to speak to someone in our office and have a quick consultation just to figure out what the options really are and what the details are that I don't have sort of from your question here. It'd be a good idea to have your contract and any information about the change as well as when that's being implemented. So if they've given you significant notice, depending on what your contract says, it could be sufficient notice for them to make a change like that and it be acceptable. Again, like the classic lawyer answer, it depends. So I would say it's a good idea to talk to someone in our office. Nancy on YouTube. If an employer cuts your hours to reduce your pay instead of changing your wage, Is that looked at the same way as cutting your pay directly? I mean, yes. A cut to your hours, which reduces your wages, versus cutting your actual wage rate, it's the same thing. The effect is the same. Your pay is changed. So yes, it would be the same. Mary from YouTube is asking, is the Ministry of Labor the same as the Department of Human Rights? No. The Ministry of Labor governs is the Ontario legislature, like it's provincial, and it is managing the employment standard. In Ontario, it would be managing the Ontario Employment Standards Act and things like the Occupational Health and Safety Act here. Across the country, they're all just sort of called different things, but the Ministry of Labor would manage labor and relations. The Department of Human Rights, I'm assuming, I've actually never heard it phrased that way, but I'm assuming you're talking about like the human rights legislation across Canada, which would be the Canada Human Rights Tribunal if you're talking about federal, and the Ontario Human Rights Tribunal, BC Human Rights Tribunal, etc., if you're talking about the provincial level ones. I'm not sure exactly what the Department of Human Rights would do or where that is sort of situated, because generally these types of things are dealt with through the tribunals that are associated with each of the human rights codes, depending on which applies to you or the situation that you're dealing with. And my last question for today is from YouTube M9HO. How does overtime work? Does it need to be pre-authorized by the employer? Overtime in Ontario, I'm going to speak to Ontario because I'm not sure where you are, is any work that you perform over 44 hours a week. There are some exceptions depending on what your position is, but they're very, very limited and very rare. Your employer can have a policy in place that says that it needs to be pre-authorized, but that doesn't necessarily preclude you from receiving overtime pay if it isn't technically pre-authorized. For instance, as long as you are asked to perform the overtime work by your employer, that's considered to be pre-authorized. If you're scheduled for it, same thing. If you have to be there for some reason, I don't know, you're told you have to be somewhere or you're not let go early enough or whatever, then same thing. If they have an issue with it, they'd have to raise it along the way. There are exceptions to overtime that can be applied for through the Ministry of Labor by certain employers. But those exceptions would be, you would have had to sign off on them along the way. It's not just a thing that just happens. It's not a thing that would happen. I think you have to sign off on it every 2 years. Those sometimes exist in things like kitchens and like for chefs and stuff like that. One thing that I've noticed people don't really seem to be knowledgeable about, or that their employers are dishonest about, is that you are entitled to overtime pay even if you are a salaried employee. You are not only entitled to overtime pay as an hourly employee. Practically speaking, it's unlikely you will get paid the overtime pay as a salaried employee, and instead what you would be more likely to receive is paid time off or time in lieu, meaning instead of getting 1.5 times your wages for the hours that you work over the 44 per week or 12 per day or whatever it is, you would receive an hour and a half or the same sort of quotient of paid time off that sort of you can bank similarly to vacation time, and you can take that at a later time. That's just because obviously on a salary your pay is consistent, so for practicality reasons, but you are still entitled to be compensated for working overtime as a salaried employee in most positions. There are exemptions to overtime that are listed in the Employment Standards Act, for instance, doctors and lawyers. I think construction has some exemptions. Trucking, the rules are slightly different, but they're federal, usually. And so, Yeah, it's a good idea to call the Ministry of Labor for your area or the Canada Industrial Relations Board or CLC, Canada Labor Code helplines if you're not sure if you should be receiving overtime pay, and that would probably be the fastest way for you to get an answer in terms of your particular situation. If you're federally regulated, it would be the Canada Labor Code. And if you are provincially regulated, it would be whatever your employment standards board or ministry is for your area. Okay. And our next, that's all I have time for today. Thanks for coming. Our next speaker Q&A is tomorrow with my boss, Leor, at 1 p.m. So if you had any questions that weren't answered or you need some more clarification, please feel free to contact our office and schedule a consultation if that was sort of what I recommended. And otherwise, you can show up tomorrow if you didn't get a chance to ask your question, and Leor can answer for you then. All right. Thanks so much.